President.
Attorney General, members, are we ready to proceed?
Okay. Great. Thanks.
Yes, just-
Clauses,
yeah.
clauses 1 and 2.
The question is that clauses 1 and 2 stand part of the bill. Honorable Senators, the question is that clauses 1 and 2 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clauses 1 and 2 now stand part of the bill.
Clause 3.
The question is that clause 3 stand part of the bill.
One proposes an amendment to clause 3, which has been circulated, if I may explain. It was observed during the course of the debate that as a result of a decision of the court, that the word president, which was not being amended in the original Offences Against the Persons Act in section 4A, and which the court had ruled should be read instead as the court, it was recognized that that needed to be picked up because the Law Revision Committee had not done it. In those circumstances, what is repeated for the Honourable Senate's consideration is that in subclause 6, the very exact form of words that was produced in the bill is reproduced, but then it goes further by adding on the balance of the words which were not being amended and which would have been left alone. And in that, the last 4 lines of the draft circulated, the word of relevance there is the word court, which is in the penultimate line, which would change from president to court. And that's the substance of this amendment before the Honourable Senate. We also propose that as a result of judicial interpretation and judgment, as a matter of fact, that subsection 7 of that act, which was repealed by virtue of judgment of the court, be in fact reflected here. Again, the Law Revision Committee did not do that, and it needs to be updated accordingly.
Senator Ramdeen.
Honourable Attorney General, thank you for recognizing and making the appropriate change that has been made to the amendment as presented by you. There is one suggestion that I wish to make. As with the case of Evelyn and the other case that was cited, what I want to bring to your attention is that if you just let me explain the reason why. this module of sentencing at court's pleasure is applicable in two cases. Is applicable to infants, as you know, in juveniles, and is applicable to persons who suffer an abnormality of mind. The reason why the courts have done this in this form is because those persons who are subject to that type of sentence, they don't remain in a constant state over a period of time. A person who suffers an abnormality of mind, their mental state may change. It may get worse, but it may improve. As with a juvenile who is sentenced to imprisonment, they will change over time, and as they mature, the reason why the law has provided that the court supervise it is because the court would then be an independent body that is able to modify the sentence as we go along.
Sure.
After this change had become recognized in our law, there was a decision of our Court of Appeal in Atin, where the court set down what the statutory guarantees are to a person who is subject to this type of imprisonment. I would have thought that for the purposes of those persons who would be subject to a sentence, or I should say an order of detention of this nature, I know that we don't have the amendment before you, and you don't have the judgment before you, but the Court of Appeal made it very clear in Atin, and it was the first time that the court actually set down in a proper judgment what these people are entitled to. I would have thought that if we are going to change the law to fix it in this form, that we should really put that in, as you've done, to correct it pursuant to a judgment of the court. The Court of Appeal has laid this down. It has gone to the Privy Council. It has not been changed. The authority on it is Atin. That we should just continue with the work that you've done and substitute what they would be entitled to. I don't have the judgment before me, so I'm just speaking off the top of my head. But Chief Justice Sharma in that case, that they are entitled to a review every 3 years.
Sure.
And if it is put down in that way, I can tell you this from experience, the difficulty with leaving it, as perhaps your response might be, is that we already have a decision of the Court of Appeal.
No, I think it's a very laudable suggestion, what you're actually proposing. I have not considered it at all. I am open to the suggestion. We have eminent senior with us, and you by your own experience, and my mind is wide open to the issue.
I just want to finish it. So what I'm saying is, the disadvantages of not doing it now is that frequently, because it's a decision of the court and it's not in statutory form, there are time periods of the 3 years passing.
Sure.
And only when actions are brought against the state, as you would know as well, then the registrar lists it for trial. By that time, the 3 years is gone. The condition of mind might change, and then the state is sued, which is not to anybody's benefit. So if we can, if your advisors could just probably have sight of it, and if you can have sight of it, and you look at the decision of the Court of Appeal, at the very end of the decision, you would see where the Court of Appeal has set down what needs to be done to a person who is subject to this order of detention. And I know that you can't do it now on your feet, but I'm sure that the advisors would be able to formulate some kind of formula in which we could fix the law properly once and for all and not have to rely on it. And I think it may take 2 or 3 more subsections, but I think what it will do to the benefit of those persons who would be in an order of detention, it will be of great public benefit.
I think it's subject to you, Madam Chair. I think it's an excellent suggestion. Not often that a parliament gets moved with the opportunity to improve the law. I have no objection. Perhaps, Madam Chair, you may wish to hear any other views on this?
Does anyone else wish to make a contribution? So what we can do, Attorney General, Senator Ramdin, is we will defer consideration of Clause 3, and we will come back to it. Yes?
Sure.
Sorry, through you to the Attorney General. Attorney General, I know it's something that I have just raised. I didn't get an opportunity to raise it before because I wouldn't have seen your amendment.
Yeah.
And having seen it now, I just think it's something that you should consider carefully, because it would require not just simply another subsection, it would require something a little bit more
May I suggest this? I thank Senator Ramdin for an excellent observation. This bill has not yet gone to the House. We have the option to actually make the amendment in the House and come back to the Senate so that we could tidy up the work. I give an undertaking now that I think it's a very solid and excellent suggestion, and that I will ask the team together with certain other attorneys who've helped us along this path and perhaps we could tidy it up between now and the House, and we can tidy it up as an amendment that comes back to the Senate for approval.
Whichever way you think is more tidy or efficient to you. But I just wouldn't want the staff to rush it, because this is something that affects the juveniles, it's something that affects these persons, and it's something that we could do once and for all to benefit everyone.
I thank you for this suggestion.
Yeah, may I, Madam Chair, just add and probably propose to the Honorable Attorney General, if we could have proceed, as the Honorable Chair said, to other sections of, or clauses, I should say, of the bill, and if at the end we are still unable to formulate what would be acceptable to all parties, then we could then report progress, and we could probably go on to plea discussion and plea agreement. And when we come back next week, the formula or the formulation would be sufficiently tight for us to go back into committee. So when you go to the House of Representatives with it, it would be a complete formula rather than not have it and then coming back up. Because remember, once it passes up, you go downstairs. Let's say downstairs, right? You have to come back upstairs again. So I was wondering if it wouldn't be a cleaner finish for us to go through, suspend, report progress,
Sure.
go to plea discussion, plea agreement, and then come back.
May I just, through you, Madam Chair, and thank you for indulging us on a point of law. I think that there's merit in the approach recommended by Senator Mark, but I fear that we may risk losing work. And remember, Parliament ends we must stop by the first week of July, come back after the first week of September. So we do have tail end to tidy it up. The person who I propose to give me the advice on this, and I thank Senator Ramdeen for raising it, is not in the jurisdiction right now. And leading member of the bar, the criminal bar in particular. So I don't believe we'd be able to fix it on the floor now, but I do give the undertaking now to look at the issue. I think it's an excellent opportunity for us. It can come back just as a House amendment to the Senate for approval, and then we can also discuss it there as well. So subject to that approach being recommended, my proposal is that we actually consider clause 3 now, but I've given the undertaking on the floor. No, there's a committee of undertakings as well.
All right, so members, the question therefore is that clause 3 be amended as circulated. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 3 as amended now stand part of the bill. Okay.
Clause 4.
The question is that, let me just put it, the question is that clause 4 stand part of the bill.
Could I just
Sure.
put the amendment? Madam Chair, we propose that clause 4 be amended as circulated to the Honourable Senate. There are two particular subcategories of amendment. The first one is in relation to a tidying of language in the proposed section 6.1, that instead of the more archaic expression, committed for trial shall be tried on indictment, that we go with the more renovated language of against whom an indictment has been filed. That's the advice on the CPC's end in terms of tidying up. The larger amendment that's been circulated, just by way of explanation to honourable members, proposes that we modify by a more prescriptive method what happens in terms of process when a person is electing to come before a judge to indicate the election for judge and jury or judge alone. In dealing with this amendment, we therefore propose to effectively change from clauses 2. So this is clause 4A, and if we look at the original bill from page 3 over to page 4, we're proposing that we completely change subclause 2, 3, and 4. We delete those effectively, and we restate them in the draft as circulated and as shown in the marked up version, to treat with the process of coming before a court. That would mean, and members would find it at pages 3 and 4 of the marked up bill, we would, in the new subclause 2, we would demonstrate what happens at the first hearing. So it would read now, at the first hearing after an indictment has been filed, the judge shall inform the accused person that he may elect to be tried by judge and jury or judge alone, unless the accused indicates an intention to enter a plea of guilt. There's a new subclause 3, where the accused person does not make the election at that trial, he shall file his election with the registrar of the Supreme Court and serve a copy on the prosecution within 28 days. So it allows the person a second opportunity, having missed the opportunity at the first occasion. The new subclause 4, we seek to add some procedural safeguards moving down now. The court shall make an order that the accused person be tried by judge alone if it is satisfied that the accused person has sought and received advice from an attorney at law in relation to the trial by a judge alone, and has filed with the registrar a Form 31. This appears a little bit later in your marked up version and in the bill. At the marked up version, it's at page 9. And this form is to give a procedural safeguard where the attorney at law will actually sign on, much like a consent order in court, indicating that not only has the accused consented, but his attorney at law has also indicated the advice and consent. When we come to the subclause 5, we're dealing now with the situation where you don't have an attorney at law. And again, the court is inviting the confirmation by the accused that he's waived the right, but more particularly that the accused indicates in writing that that right has been waived. And that's in a new Form 32. Both in the new Form 31 and Form 32, you will see that there's cautionary language indicating I've not been threatened, I've not been coerced, etc., into giving up this position that I previously had. And then in the subclause 6 that we come to, we have the prescriptions for caution, that the court should not make an order for trial by judge alone unless it's satisfied of a number of matters, that the case that in a joint trial that all other accused, etc., have elected, and where there are 2 or more charges, the accused person has elected to be charged to be tried by judge only for all of those. The new subclause 7, which appears at page 5 of the marked up version, deals with the position of a court making an order under 405, that's what we just previously discussed. The accused person may subsequently apply to the court for a trial before a judge and jury, or the converse, that whilst you may have been locked in a judge and jury matter, you can actually go for judge only. So 7 is where we allow for the options, and 7 is subject to the new 8. And 8 says that basically you could change your mind right through until 28 days prior to your trial. We may wish to consider, I did have a chat with Senator Roach as we were just sitting to start, an indication that the judge may have a discretion to alter that time frame. That's usually consequent in certain matters. And then 9 indicates the new subclause 9, where an accused person makes an application in accordance with subsections 7A and 8, that the court shall make an order granting the application, or 7B and 8, the court shall, subject to meeting the conditions for judge only, then direct it that way. So it's the natural progression through. Those are the amendments in a nutshell and rationale that we propose to clause 4 of the bill. We also, because clause 4 is continuing, we propose further that clause 4B stays the same, clause 4C stays the same, but when we get to clause 4D, that we're now renovating the giving of reasons and the time for giving reasons, and what we propose, which members will see into the bill, we're proposing that we add in, we change the language of 42B And we say that where the case on both sides is closed, the judge shall give a written judgment stating the reasons for the conviction of the accused person at the time of conviction. Previously, we would have had the language acquittal or conviction. So we're keeping it only to conviction now, that you must give the reasons at the time of conviction. And that is a synonymous event, a simultaneous event. Then we are adding in that subject to subsection 5, we're adding in a new subsection 4 and 5, that where an accused person is acquitted in a trial by a judge alone, the judge may give reasons. The next clause is where the prosecution requests the reasons for an acquittal, that the judge shall give reasons. So put simply now, we're saying no longer will we allow for the judge to give reasons as soon as is practicable. We're telling the judge, give the reasons at the time you give the conviction. If you're going to convict, give it in writing at that time. If you're going to acquit, you may wish to give it at the same time. But in any event, if ever the prosecution asks you for the reasons for acquittal, you must give it within 7 days, therefore allowing the prosecution the opportunity to appeal on the basis of written reasons. We propose some tidying up in subclause L by inserting the forms that we've just spoken about. So after Form 30, that we will actually add in the Form 31 and Form 32. So that's at page 4 of the draft circulated, and page 5, that's of the amendment itself. And those, in a nutshell, are the amendments proposed to Clause 4 of the bill. I interrupted, through you, Madam Chair. Senator Ramdeen was about to indicate something.
I inadvertently came in because before you went to Clause 4, if I could be allowed by Madam Chair, I just wanted, when we passed Clause 1 and 2,
Yes.
there was one issue in your amendment to the Supreme Court of Judicature Act at Chapter 401, and I just wanted to
We haven't dealt with that as yet.
Oh,
We haven't come
That
to
comes
that.
at a
As
new,
you please.
that's
That will come
new
in.
clauses at the end of Clause 5.
Yeah,
yeah, as you please. I'm obliged.
yeah. So, honorable senators, the question is that Clause 4 be amended as circulated. Those in favor say aye.
Aye.
Those against say no.
Madam Chair, I wanted to address some matters in Clause 4 before we actually go to the
Sure,
vote.
of
I only
course.
mentioned that because it was Clause 2. Can I, with your leave?
Yes.
AG, when you come to clause, your new subclause 3,
Yeah.
where you set out that where an accused person does not make an election at that hearing, he shall file his election with the registrar of the Supreme Court and serve a copy on the prosecution within 28 days of the adjournment of that matter or with leave of the court at a later date. I have a bit of a concern with that in relation to persons who are incarcerated. You know that we've had these cases where, in relation to notices of appeal, you have the difficulty where you statutorily provide for something to be done within a particular period of time. For an incarcerated person, one has to consider carefully the idea of serving an election. He shall file his election with the registrar of the Supreme Court. It becomes a real difficulty with persons who are incarcerated. And I think that is something that we need to consider, because the way they dealt with it in relation to notices of appeal, they had put in a provision that allows the Court of Appeal to extend the time by amendment, so that before, where you had a fixed statutory period of 7 days, you could then make an application to the Court of Appeal to extend that time. Now, I understand that you have a provision that says, with leave of the court at a later date, but I'm not sure that you want to completely shut out the idea that someone may want to file
Election.
an election,
Yeah.
and then it may be only, the problem with these things is that it's only when you reach the hearing
In arrears.
and you realize ex post facto that this thing has not been filed. Somebody might take a point. You never know what can happen. So I was wondering if you could consider, only in relation to persons who are incarcerated, if we could do something with that particular subsection to perhaps ease the burden. Because for somebody who's incarcerated, let's just take, for example, someone who's incarcerated without a lawyer. By the time they go back into the prison, they decide what they want to do or what the position is, they get committed for whatever the position is. It takes some time. You know what the system is like inside there. They might fill out the election, they might have the form, fill it out, it gets stuck in the prison. It doesn't reach the registrar of the Supreme Court. This particular one says that it must also be served on the prosecution. That puts another burden on someone in that position. So I'm just thinking that is something that you would want to consider.
Do you have a recommendation in taking care of the vicissitudes we had sought to put in with the leave of the court? But I accept your point that we may be dealing with something ex post facto, and then you're chasing the result that you may have missed. I was sort of banking on the fact that once you're remanded, that you would be returned every 28 days, etc., and at least the court would have had some degree of sight as to where you go.
But this would be after. The problem with this is that this is after you've committed. So you're now in the you're there after the indictment is filed. After the indictment is filed and you do first cause list, then you're not coming back at all.
What do you suggest, Senator?
I mean, because of the period of time that we've had, I'm not able to formulate to you an amendment that will suit it.
Senator Roach is also seeking to make an intervention.
Thank you, Madam. Urging, if you will take out, instead of with the leave of the court, and instead supplement, put instead, as the court may so determine, or may so order. So you take it out with the leave, so.
The rationale for leave, sorry, Madam Chair.
Attorney General, before you answer, Senator Sturge, you wanted to raise something? Okay, yes.
Sure. Senator Roach, I had inserted leave so that you could get an order. So it was to indicate that at least you'd make an application or bring it to the court's attention. So I sort of read the order flowing from the leave. Well, the point is that one should have the opportunity to enlarge the time to meet the circumstances and the justice of the case.
If you go without saying leave, and you say, as the court may so order, you can make an oral application before the court.
Yeah, Senator Rambarat is proposing, or at a later date as the court may order, the spirit of the proposal. Yeah.
Yes, sir.
Make sure, because it opens the door for you to make an application at any point in time subsequent to the first hearing.
So let's look at that. Where the accused person does not make an election at the hearing, he shall file his election with the registrar of the Supreme Court and serve a copy on the prosecution within 28 days of the adjournment of the exam.
.420, you might be able to copy back that same provision, the amendment to 420. No, AG, no. The actual, if you get the Summary Courts Act, you will see the amendment in section, I think it's 108 or something like that, where they have actually put in the amendment to allow the person to extend the time. So you could perhaps use that section.
Honorable Attorney General, members, I will suspend for 5 minutes. All right, I'll just be, yeah.
Before you actually make that decision, I was just wondering if it wouldn't be more prudent, as the Attorney General is taking advice on this said section, if we could perhaps go through the other parts that I have concerns with, and then we could stand it down, and the Attorney General could deal with all during that time. Just a more efficient use of time.
Yeah,
Very prudent.
sure.
Yeah.
All right. Senator Ramdeen.
AG, I looked at your Form 31,
Yeah.
right? And while there is much benefit to be gained by having the Form 31 in this form, I can see it being problematic from the second sentence where what we are doing is the purpose for which you are doing the form is to ensure that whoever is the subject of such an election is protected by being advised properly. I guess that's the intention, which is a noble one. But the problem with this is that without actually putting something minimum as to what the attorney should advise the person of, I think it leaves the door open for some persons to get proper advice as to what the election should be and what perhaps their rights they're giving up, as opposed to someone who doesn't give them proper advice by just simply telling them, sign the form. Before we came back here, I was explaining, like, when you go to take a mortgage in the bank, and the banks have formulated the position of you taking a mortgage with your wife, and you know that you have to get legal advice because of the case law. They actually set out what you are taking advice on, so that I wouldn't like for us to pass this form in a form where we don't actually say, at a minimum, you should advise them of A, B, C, so that at a very minimum, you will have a guaranteed that there's a certain amount of protection that you'd be given to someone making an election, no matter who the attorney is. And it will give you more protection because at the end of the day, it will guarantee that the person who is subject to make the election has been given at least that minimum threshold of advice. Because you could come to the point where someone would then make the usual applications of not receiving proper advice. I wasn't advised properly. I signed the form, but when I was asked what the position is, I wasn't told anything.
Yeah.
So
Just through you, Madam Chair, we did look at the independent legal advice aspects that come up in mortgages in particular. And we also mirrored some of the approach that we're taking in a bill which is not yet before us, but the plea bargaining approach in that form. We were, after that, then relying upon the fact that the judge must make inquiries as to whether you actually understand the position, notwithstanding the form. But in the form itself, so I, the accused, confirm that I have sought and received advice from the undersigned attorney at law on electing. The undersigned attorney at law has advised me of my rights and of the implications of electing to be tried by a judge alone. I have had sufficient time to confer with the undersigned attorney at law concerning this mode of trial. I understand the implications of electing to be tried alone and agree to this mode of trial without reservation. Those were the points. So you think that something more should
I think problematic in that is that you have the point we see where you say advise me of my rights, and then you come after the and with of the implications. I think we should do something to set a minimum threshold there of what that entails. Leaving it open like that, I think you yourself will understand. Most of these people are advised by persons who are, and I don't want to criticize lawyers, but people who, you open a door for people to not, we've had instances in this jurisdiction where you have a capital matter, where attorney didn't know he was doing a retrial, right? So I wouldn't like for us to not get all the benefits that we can get from a form which obviously, as it stands here, it sets a very good border. If we could just fill in the gaps,
Understood.
I think that, it'll give the person who is electing much more protection.
Appreciated. Thank you. Madam Chair, may I inquire if there are other matters? I suppose that the Form 32 would also...
The same thing,
Yeah?
yeah.
Okay.
I have a concern with Clause 5, AG.
I'm sorry.
Sorry.
Number Form 5.
Apologies, the leader of the House was just discussing our timing in terms of the usual agreements, Madam Chair, that we come up to, and that we should be careful not to indulge the Senate's time on the next bill. So I'm just flagging that we may ask you to consider ending at the end of this bill. as opposed to
I
delaying the
hope I
Senate.
could run through what we
Yes,
have to do
please.
here.
Through you, Madam Chair, with your, before the procedural motion? Okay. Yes, section 5.
AG, I know this is something that you would probably want to think carefully about, but I am not comfortable in allowing anyone to elect to trial by judge alone without receiving legal advice, no matter how. I think it's a protection that has a lot of problems that can flow from it. So I know it's a big step, unlike the others that I'm comfortable with 5A and the fact of giving, 5A and 5B, the fact of giving someone the right to elect for something as serious as this without getting legal advice and giving up that right. I don't think that we should take away that kind of protection, because as this thing applies to people who are on capital matters. You yourself, in wrapping up, understood that the frustration alone that people go through after sitting through a PI stage and waiting for an indictment to be filed for 10 years, it opens the door for somebody to just out of pure frustration say, give me a judge alone trial,
Sure.
and move on with it. And I don't think that we should legislate to take away the right of legal advice for somebody for something as serious as this. So you can consider it, but I don't think that I'm not comfortable with the provision in terms of taking away, allowing someone to elect a judge alone trial without legal advice.
Sure. Madam Chair, would you permit me one moment?
Sure.
Senator Ramlin, is there much more in terms of observations? Okay, sure.
Right, I just wanted to go through them. As you please.
We'll take it, I'll leave at 7:39 to go.
Yes, ma'am.
Yeah.
So after the procedural, you leave?
After I take the procedural motion, I'll come back and then we will decide if the, yeah.
And-
Leader of government business.
Thank you, Madam President. Madam President, in accordance with Standing Order 14.5, I beg to move that the Senate continue to sit until the completion of the business at hand.
Honorable Senators, the question is that the Senate continue to sit until the completion of the business at hand. Those in favor say aye. Aye. Those against say no. The ayes have it. The Senate will continue to sit until the completion of the business at hand. Are we in a position to deal with stand down clause 4, deal with clause 5, or shall I suspend at this stage?
Madam Chair, what I'm proposing, if you'd permit me to just think aloud, or rather share my thoughts aloud, I really wish to thank honourable senators and Senator Ramlin in particular for giving the thought to the work that we have before us. I'm minded, with your permission and with due and proper process, to hear the observations of the honourable senators, and if necessary, insofar as we are proposing that we do not commence the second bill because of how long we've been sitting as a Senate, that we could perhaps take the committee stage on the next day and then start the other bill, because We wouldn't want to truncate the rhythm of the second bill where senators may want to come in. If I can share my situation openly, I'm very concerned that we may run out of parliamentary time. I had adjourned considering a number of these matters to allow the Law Association to give commentary, but they didn't. And we waited for a very long time for them, and we really can't compel them to give us their thoughts. We did get some great assistance from members of the criminal bar on this matter. Senator Ramlin has raised some very important points that I think deserve consideration. So thinking aloud, and I know we've not had, because the leader of government business has whispered to me, the opportunity to speak to either the coordinator or the leader of the opposition bench. In light of my fear of the parliamentary time, I don't know what honourable senator's position would be in starting a little earlier on the next Tuesday. The advantage, of course, in starting early is that we get to do some more fulsome work. But again, the government can't impose itself on the time of the Honourable Senate. So I'm just sharing that aloud, Madam Chair, and for those reasons I would propose that we hear the other observations for the other clauses, and then, subject to the will of the Senate, treat with it as we may agree.
Madam Chair, I think that the Attorney General has advanced some thoughts on a matter that is very critical before us. First of all, I agree that we should try to explore fully and finally any additional concerns members of the Senate may have on the remaining clauses that we are yet to traverse or address. And having done that, Madam Chair, if I'm hearing what the Attorney General is saying, we will suspend, report progress, and when we meet next week, Tuesday, suggesting that we come in a little earlier so we can go through the committee stage and finalize this bill, and then go on to plea discussion and plea agreement. We have no objection to that, and we normally would start 10:30 in the morning.
And to you, Senator Mahabir, that we can go through this because apparently the amendment will call for some time. So instead of going to the House and coming back,
Yes.
so we could complete the committee stage here early. So would you have
Making
any
sense.
objection to 10:30?
No problem.
On
We are
Tuesday?
okay. We are okay with 10:30.
Okay, thanks
Yeah.
very much. I appreciate it.
Yeah, 10:30 is good.
Yeah, good.
10:30, ma'am.
Appreciated.
Yeah.
Madam Chair, in your hands then, in terms of facilitating the observations on any other clauses.
Well, let me just ask, are there any more observations on the amendments to clause 4? Well, then, could we, yes, because with Senator Ramlin, you dealt with the forms.
My next concern is at 8.
Madam Chair, if you will permit me, before Senator Ramdeen gives his issues with Clause 4, Attorney General, please note that we did start this debate in March, and I know you were waiting for time, but you have put us in a very big inconvenience because these are now new clauses, and I have not heard other members' points on these other clauses. We're only hearing from one senator from the opposition and yourself for the government. So I would prefer that we take Clause 4 in the new on Tuesdays, where we could get some time to research these clauses, because remember, these are new legal terms coming in. We're repealing amendments. We're putting in new amendments. I would prefer we have the time to do that.
Yes,
Thank you.
Senator Ramki soon. That is what is being proposed, okay? So that we will come back and resume the committee stage next week, Tuesday. So that is what is being proposed. All right?
Just to join in, Madam Chair, the Committee of the Whole on all of it will be wide open for everyone to contribute. What we're hearing so far is, and Senator Ramlin has drawn a very careful caveat, these are just his initial observations, because he too has said that he hasn't had the time to give proper fulmination. So I'm not holding him to an exhaustive position now. He may very well have the members of the opposition further observations, which the government wants to entertain and treat with.
Okay, so we still at the amendments, the proposed amendments to clause 4, correct? Senator Ramdeen? Continue, yes.
Yeah, AG, at your new clause 8, I think it is a good suggestion to set a time before which the trial is made for that election to be made. But I think the period is a bit short. As you know, if you have, I can foresee a situation where if somebody's changing from judge alone to judge and jury, or the other way around, most of the times you might want to get new counsel. And if that is the position, at least under the civil proceeding rules, when you have to file trial bundles for the notice of the judge, you at least do it 42 days before the trial. I think 28 days is too close to the end of the trial.
Do you have a figure in mind?
I would have thought at the very least, perhaps 60 days. From the date of the causeless hearing, the trials are set quite long away from the first causeless hearing.
Sure.
So I would have thought
no
that
objections at all.
I consider between 60 to 90 days. But I think that would give the court and the accused enough time, even if a new counsel has to come in, because you have an election, a new counsel comes in, you make the election 28 days, you go before the judge, and then the whole trial gets adjourned.
The members of the criminal bar that recommended these thoughts actually had 14 days, and I said that there was no way that could happen. It was in the Cayman vein of thought. So I appreciate your reflections.
Madam Chairman, I'm sorry to interrupt. May I?
Yes, please. Yes.
No.
I
Yeah.
give way to Senator Choot.
I would like us to exercise some caution, because remember, some of these discussions you may have had with members of the criminal bar may have taken place before the criminal procedure rules
After.
kicked in. So timelines now have to be considered in accordance with the criminal procedure rules, and I think the break that we have between now and the next sitting will allow us to do a proper comparison in terms of timelines between what is provided in the legislation and what is provided in the rules.
Excellent point. Appreciated. Thank you, Senator. Which actually impacts somewhat on the other bill that we may consider as well. Yes. Madam Chair.
D, page 7, that still falls within your section 4, does it not?
Yes,
The
it
ninth
does.
page? I don't think we should legislate this the way it is. I could see it causing real problems, because I think as you have set a time limit in relation to the giving of reasons where you have an acquittal
On page 6.
on page 6, sorry, on page
Just
8.
conviction. Page 8, yes.
Yeah. I can't agree that we should allow the judge to simply give reasons at
If
a
asked,
date.
I wrestled with this. In my mind, you should have given the reasons on acquittal or conviction
No,
at
I'm
the
not on
same
that.
time. Is it
no,
that
no,
one?
No. I'm on 42B, where you've said that you're providing when what you've added is of the accused person at the time of conviction.
Right.
Now, without setting your motive when you turn over leaf on 8 is laudable, because you've now set a timeline for the judge to give reasons of 7 days, and I'll come to that.
Yeah.
But in relation to this provision here, without setting a timeline, AG, I can tell you, and I'll say openly in Parliament.
Say it a different way.
No, I don't think it's going to be pejorative.
No, it's not
Madam
going to be.
Chair. Yeah.
I have done FOIs where there is a judge sitting on the High Court bench that has 42 judgments that are outstanding for more than 7 years.
That's why I said, and please take my guidance, to be very careful about what we are saying, okay?
No, I'm not calling any names.
No, it doesn't matter whether names are called or not. It's the standing order that is being infringed.
AG,
So, Attorney General,
yeah,
Senator Ramdeen, continue the discussions, but
Sure.
on a certain line.
Madam Chair, this might sound on a rare occasion, but I do thoroughly accept what Senator Ramdeen is saying. I didn't get it that he was being pejorative, but I'm guided by you.
No, please,
Yeah.
whether it's accepted or not,
Yeah.
my responsibility is to the standing orders. And please, I'm trying to steer everyone clear. Just please abide by the standing orders. So it can be exchanged in a different way.
Yeah, okay, as you please, as you please. AG, I don't want a situation to arise where you have a very long period of time between the end of the trial and the giving of the reasons, because the way the legislation is
Yes,
structured,
yes.
what you have is that the only thing that limits the judge in giving the decision on trial is whenever the reasons are there.
Correct.
So it opens the door for there to be a lot of arbitrariness.
And just to point out, the judiciary, in its difficulties of resourcing, etc., had recommended the original version of this was at the time of conviction or acquittal, or as soon as reasonably practicable thereafter, which itself has fallen into a lot of complaint by persons. The prescription for time frame that you're suggesting is that X number of days after the end of the trial. It's that sort of formula you're looking
you
at.
see, AG, you already have done it in relation to acquittal. I'll come to that. But
Yeah.
it doesn't fit well that you've done it for acquittal and then for the substantive trial itself, which is perhaps more important, you just leave it open.
Well, but we've done it for acquittal from conviction as well, just for the production of reasons.
Of course, yeah, but what I'm saying is, I don't want to support a piece of legislation that leaves it open-ended like this.
What
If we look at Ramnarine in the Privy Council, you would see that I think in Ramnarine they suggested a number of months. On this issue, there are a number of judgments. There's a Privy Council judgment out of Jamaica, and there's Ramnarine from our own jurisdiction that deals with what is reasonable for a judge to deliver reasons.
Question.
Now, the one thing we have to be careful about in this is that because you have a judge alone trial, you run into the same problem that we have with civil trials, which is the longer the period of time that elapses between the giving of the evidence and the writing of the reasons and coming to the decision. The judge is a human being. He'll forget about the impression of the witnesses. He's the judge of fact in this particular case, and therefore we must be conscious that the judge who is doing this is going to be the judge in a judge alone trial, is going to be the judge of fact and law.
What about a hybrid formula which suggests, after reflecting on Jamaica case or Ramnarine, a link which says, for instance, and I'm just throwing it out, 3 months or such other time. My fear is that the complexities or the vicissitudes of the different types of cases may come into kick. It may be a very complex fraud trial where the evidence can't be harnessed into factual determination.
Well, let's just take for example Vindra Naipol. I mean, a judge who has to sit down and listen for evidence for over a year and a half or 2 years to tell him to deliver a judgment on the facts of that particular case in a month or 2 months or whatever. I think this one is something that you should have some consultation with the judiciary on and get their view on it, because at the end of the day, it falls to their feet to be comfortable with what
their view was the first version of the bill, which is as soon as is practicable.
I'm not going to agree to that. I think that you should suggest, as Attorney General, I think that the right thing to do is suggest that you are going to fix a time frame and get a time frame that is workable, at least giving them the opportunity to be heard as the principal in the administration of justice. But I don't think we should leave it as open-ended as this. I don't think we should leave it a reasonable time. We have to also remember that this is a superior court of record, so that you wouldn't be able to get judicial review against them in relation to if there's a delay. You'll have to go under the Constitution, and then you have problems there. So I think this is one that you should have some consultation with them.
We did. I'm noting your concerns well, and we'll go back to
Sure.
some further reflections. Please, Madam Chair, through you.
Madam Chair, through you. Just to elaborate on what Senator Ramdin is saying. If there's a difficulty with the judiciary talking about reasonableness, and he says it's open, and I understand that. What about if a time is fixed, and then if there's an extension, it has to be on with the approval of the parties involved, or such time as the parties may approve. I mean, you have to agree on it now, but that can be a source of bringing back the persons who will be affected in having a say in what time will be reasonable in circumstances.
Thank you, Senator. It was along the lines of hybridizing, but I can see the various camps taking entrenched positions one way or the other. But I do appreciate the points that honourable senators are raising.
The problem with that suggestion is that bringing back the parties is a very good idea. The problem is you're coming back before the judge, who has to decide whether he's going to give himself more time. So that is where the problem is in relation to that.
Well accepted. Any other observations through you, Madam Chair?
In respect of with respect to 4 and 5 AG of D, I don't think we could. I don't think we could realistically agree to 7 days. I mean, a magistrate under the Summary Courts Act has 60 days. If they have to appeal, the appeal is not going to come up anytime soon. And I don't think I just don't think that it's practicable to give a judge 7 days for reasons like this. The reasons that the judge would acquit would require the judge to apply his mind to the same facts and the same law as if he has to convict. So that the expression of reasons, the fact that it's an acquittal, I think that whatever period of time that we're going to agree in relation to the conviction, I don't see why it should be any different in relation to the acquittal.
We had two choices here, and we cleaved on one, and I hadn't wedded myself one way or the other. And that was whether the judge ought to give reasons for acquittal and conviction, full stop, and not cleave in the discretionary approach that we've recommended here. This discretionary approach that you are only producing reasons when invited by the prosecution to do so was driven out of the criminal bar itself, that felt that it should go that way. But I'm certainly not wedded one way or the other to the point.
I have no difficulty in the practicality of that, because why should a judge give? I'm not going to. I don't think that we should support a position that he gives reasons anyway.
Yeah.
Whether it be, I understand the practical reality of giving reasons only when it's required.
Yeah.
Why we should give them given reasons when the acquittal is there and there's no appeal.
Yeah.
The position is that I think that the 7 days is what I'm concerned about.
Sure.
Because I don't think that it's realistic. So I'm just on the time period. I'm with you on the policy behind it. I think it's laudable in terms of giving it only when it's required for appeal. But I just think that whatever we do with the time period in relation to 442B, we do the same thing in relation to
Appreciate it.
in relation to 5. And I think there's no. Oh, right. With respect to G and H, these are the provisions where, and I don't know if there are any others. If there are any others, I stand to be corrected. I hear you when it comes to taking away the discretion from a jury in relation to these particular types of matters. I think that a procedural safeguard that we should put in, having regard to the fact that we are excluding the jury totally in these are not the optional ones, if you want to put it that way, is that in relation to 64 and 65, where a judge is going to make a decision that is going to affect the conduct of the trial and what takes place with that accused person, and there's no intervention or option to go for a jury, that the judge should give reasons in relation to that as a matter of fairness. So you perhaps would want to consider that in relation to 64 and in relation to 65. I don't know if there's any other provision in relation to 63. No, I think in 63 you have an option. 64 and 65 are the ones where you don't have an option. You don't have.
Senator Mark, I recall, through you, Madam Chair, forgive me, I recall the observations you made during the debate, which a couple other senators on the independent bench also echoed. So I'm going to look at those in a little bit deeper sense for the diminished, for the reduction as a result of diminished capacity, if I could put it that way.
My concerns in relation to section, in that section, is it section 5? 4.
Any other members, any additional comments on clause 4? So we will defer consideration of clause 4.
Yes, please, ma'am.
Clause 5.
Honourable Senators, the question is that clause 5 stand part of the bill. Attorney General, I believe there are amendments circulated.
Yes, ma'am. My mind was just reflecting upon the fact that we had actually agreed to clause 3, and I would ask you after this to return to that so that we can actually defer consideration of that as well, subject to the will of the Senate, to allow for the reflections that Senator Ramdeen brought up in relation to that, which we had given the undertaking on.
I know that your parliamentary time is very limited, and that's why the leader and you want us to agree to do that. Perhaps unconventionally, if you get your advice.
So I'm agreeing with you. I'm asking Madam Chair afterwards to go back to it, to unlock it,
Right,
So
so
this-
that, what I'm just suggesting, if you get your advice, as you've done in all of these bills, if you get your advice by Monday, and you put something in draft, at least we could see it before
Sure.
Tuesday. If you could just perhaps email it to the respective conveners of the respective benches, and if there are any suggestions that we can make to improve it, it would save the time on Tuesday,
It's an
and we
excellent
could
idea.
also make whatever changes we can, so that on Tuesday,
I see Madam Chair smiling in disbelief at our committee. I'm just teasing. But
Just to ask though, because I'm appreciating what is being suggested, but clause 3 was amended.
which is why I'm asking you, Madam Chair, that we actually go back to clause 3 to agree to revisit
Yeah,
it
he's
and then
asking to
suspend
revisit
it.
clause 3
So
and
therefore-
reopen.
To reopen clause.
Yes, ma'am. Yes.
Revisit and reopen.
And for the same reasons volunteered. And the thinking is that once we've got something, that we can circulate it in advance as quickly as possible.
Procedurally, Madam Chair, would you have to?
I think
Clause 3,
yes.
clause 3
Yes.
revisited, yes.
So, honorable senators, the question is that that this committee do revisit clause 3.
Yes, ma'am. Madam Chair, I propose that we take on, I'm sorry, did you need to ask for all in favor? Or?
All in favor? Aye. The ayes have it. Clause 3 will now be revisited. It no longer stands part of the bill as amended.
Thank you, Madam Chair. We propose to take on board the observations of the Senate and to come back on the next occasion with recommendations that could meet with some of the observations that the Senate has so far given. I, of course, note for the record that honourable senators may have further observations to give, and, of course, the government is open to listening to that.
All right, so may I ask at this stage, because what I intended to do was to go through the bill and then defer consideration of the different clauses. But as I was doing that, I was kind of stopped. So I just want to make sure that we're on the same page.
Yes, please.
So clause 4, we have deferred consideration. I'm now moving on to clause 5.
Clause 5.
The question is that clause 5 stand part of the bill.
Madam Chair,
Attorney General.
we have proposed a circulated amendment to Clause 5. Previously, we had said that the Act did not apply to any trial on indictment that began under the Criminal Procedure Act. We're proposing now to clarify that language to allow for us to tackle some of the backlog by saying that the Act will apply to an indictment for which the trial has not begun under the Criminal Proceeding Act. And then to specify further that the Act does not apply to any trial on indictment that began under the Criminal Procedure Act prior to commencement of the Act. It was the suggested language to allow us to facilitate the entry into this selection and election process where trials had not begun, but that we wouldn't unduly cloud the situation to cause people to challenge rights or seek clarification from the court as to whether they could participate or not in the mechanism. I'm open to the observations of the Honourable Senate on this clause.
Perhaps a difficulty with the application of 5.1, because you would have people in the system who would have passed the first hearing date under.
Yeah, where you could elect or then come 28 days
Yeah.
after.
So while you can if you can find a way to capture them without falling afoul of what we would have already been providing for at 8 and 9, it would help you to clear up the backlog and also facilitate the whatever procedure is engaged. It will be in accordance. You would, because you could just make an exception, some way, find a way of making an exception for those persons to be able to engage the provisions of the Act, but still not breach the provisions of the Act by virtue of the timelines having already been passed. Because you have a lot of people in the system who would have just come up before it was
Appreciated.
discharged and then gone back into the system.
Yeah.
Period of time would have passed under the Act. So perhaps we could find some way
Sure.
of formulating.
Some further transitional language.
Yeah, you could do it in the form of a transitional provision.
Yeah.
And perhaps set a timeline on it. So you could probably consider perhaps doing a sunset clause for that particular provision so that it will cut off at a particular point in time that is suitable to you. Check with the administration and see what the position is.
Appreciated. Madam Chair.
Senator Ma?
Are you Are you through, ma'am?
No, I'm asking, do you have any observations on clause 5?
No.
No? Any other member? So clause 5 is now deferred for further consideration.
New clause 6.
It's, yeah. It's a new clause 2A and 2B, Madam Chair.
Please, I'm not following you where the 2A and 2B.
It's on page 6 of the circulated amendments,
all right.
and
Thank you
new
very
clauses come last.
Yeah, okay. Thank you very much, AG.
This, I'll let Madam Chair put the question first. Sorry. It's on the page 6 of the circulated amendment, so it comes after you see the two schedules, the two new forms, 31 and 32. If you turn over from that, there's the new 5, which you would have seen in the marked up version. So it's the first few pages of the bill, of the circulated amendments. On page 6 of the circulated amendments, the 5 you would have seen reflected, and the new clauses 2A and 2B are to take care of the omissions that happened in the Supreme Court of Judicature Act and in the Court of Appeal rules, where we hadn't modified to include judge only as opposed to judge and jury, and specifically an amendment to Section 100 of the Summary Courts Act for the same reason. And then what would have gone consequentially from that was the need to amend the long title, because the long title would only have reference to bits of legislation as opposed to including the Supreme Court of Judicature and Summary Courts Act. I think we jumped the gun on you, Madam Chair.
Are you finishing your discussions?
Well, members hadn't spotted it because one thinks that forms usually come at the end, so you are tempted not to look right down to the end of it. So I'm open to any observations subject to your guidance on new
Members?
clauses 2A and B.
Yeah, members? Any?
The amendment to Section 100 of the Summary Courts Act, when you look at the substantive act, this is the provision that allows the hybrid offences.
Correct.
For the explanation. I thought that you would probably want to consider that in addition to just simply adding or by judge alone in relation to Section 100, subsection 3, that before that in the substantive law, if you have it before you, you would see that for the hybrid offence, the magistrate would explain first the choice, but then what we haven't catered for is for explaining what it is to be tried by judge alone, even though you're now putting in judge alone. So the same right that should be given to the accused
Yes.
for the hybrid offence, could we just give it to the accused in relation to the fact that we're now adding judge alone? So the magistrate will just simply explain to the person that they would have that option and what it is.
So a reflection of what we are doing for the criminal proceedings position with the explanation there. I catch you.
Yeah.
Right.
Those are my observations.
All right.
Sincerely appreciated.
So, Honourable Senators, unless anyone else has any, Senator
Yes.
Mark?
Well, just two observations, if you allow me. I did recall the Honorable AG given an undertaking to report to the Senate on the possibility of a sunset clause.
Yes.
I don't know if you are in a
Yes,
position to do that now.
I did reach out for response. I haven't gotten it. Senator Crease had asked that. And Senator Ramlin has echoed it in a tighter way in respect of the transitional provisions. So I will certainly come back to that. I didn't get the response yet for Senator Crease.
My point is whether the Honorable Attorney General, in fact, whether, for instance, the Attorney General would want to consider a provision that would allow a review of the legislation. Not so much talking about like a sunset clause, like every 3 or 4 years, but you know, sometimes you may have a provision in the legislation where, because of the effluxion of time,
It's in the Dangerous Drugs Act. I saw the formula that you're looking for.
You have a review, Madam Chair, of the legislation. I don't know if that's something you may want to examine as well.
I'll look for it and look for the precedents on it and consider.
Okay, so honorable senators, consideration on the new sections will also be deferred. Okay? Honorable Attorney General.
Yes, ma'am.
General.
Madam Chair, sorry, just to catch up with you. We've considered so far, without prejudice to further observations, a number of issues. Do we do the report for recommendation to the Senate yet? Is that what you're inviting me to indicate?
I'm inviting you to just.
Madam President, I wish to report that an act. So, Madam President, Madam Chairman in committee, in accordance with Standing Order 6814, I beg to move that progress on the bill be reported to the Senate.
Honorable Senators, the question is that progress on the bill be reported to the Senate. Those in favor say aye. Aye. Those against say no. The ayes have it. The Senate will be resumed. General.
Madam President, I wish to report that an act to amend the Offences Against the Person Act, Chapter 1108, and the Criminal Procedure Act, Chapter 1202, and for related matters was considered in committee. However, the deliberations on the bill were not concluded. I therefore seek the leave of the Senate to resume committee stage on Tuesday, 13th of June, 2017. I think it'll be for the Leader of the House to indicate the time. Thank you, ma'am.
Honorable Senators, the question is that the committee stage of the bill be resumed on Tuesday, the 13th of June, 2017. Those in favor say aye. Aye. Those against say no. The ayes have it. The committee stage of the bill will be resumed on Tuesday, the 13th of June, 2017. Leader of Government Business.
Thank you, Madam President. Madam President, I beg to move that this Senate do now adjourn to Tuesday, the 13th of June, 2017 at 10:30 a.m. During that sitting, we will conclude the committee stage of the miscellaneous provisions trial by judge only bill. Then we will proceed to do the two motions on the order paper. One for the Vision 2030 to go into to be put to a joint select committee, and one for the review of the levels of healthcare delivery at the Regional Health Authority to go before a joint selected committee. Hopefully those debates wouldn't be long, and we still hope at the back end of the day to begin the debate on trial by judge. Plea bargaining, sorry, yeah.
Honorable Senators, before I put the question on the adjournment, leave has been granted for two matters to be raised on the motion for the adjournment of the Senate. Senator Mark.
Thank you very much. Yeah. Madam President, thank you very much. Madam President, I rise to address an issue dealing with a statement which was issued by the Ministry of Public Administration and Communication, dated May the 12th, 2017, entitled Greater Power to Permanent Secretaries. And in that statement, Madam President, it is stated that the Public Service Commission will allow permanent secretaries in 5 specific ministries to fill a number of vacancies. And that release went on to say as well that the whole recruitment and the filling of vacancies will now be addressed on a specific basis, meaning vacancies will be filled as agreed by the ministries themselves, who would have the responsibility of advertising these positions, and the permanent secretaries can fill these positions accordingly. Madam President, what is also important to note in this statement or media release is that the Ministry of Health, there are 6 ministries involved. The Ministry of Health, the Ministry of Energy and Energy Industries, the Ministry of Public Administration and Communications, the Ministry of Rural Development and Local Government, the Office of the Prime Minister, and the Ministry of Community Development, Culture and the Arts. The impression that one got here, Madam President, is that the new arrangement approved, that is the language, by the Public Service Commission will only be in place in the following ministry. Now, we are being told that this has been approved according to this release. And if I may advise, I know that under the Constitution of the Republic of TNT, the Public Service Commission under 120, 121 exists, and they are clearly outlined in terms of their powers and functions. And under 127, subsection 1 of the Constitution, there's a provision that says that the Service Commission, with the approval of the Prime Minister, and subject to such conditions as it thinks fit delegate any of its function other than any power conferred on the Commission by Section 129. Now, Madam President, I raise this matter in the context of Section 85(1) of the Constitution, because this is a very dangerous area that we are traversing at this time. Because under 85(1) of the Constitution, the minister exercises general direction and control over his ministry, and subject to such direction and control, he has under, the department shall be under the supervision of a permanent secretary, whose office shall be a public office. So the independence, impartiality, fairness, and neutrality of the Public Service Commission in appointing, transferring, disciplining, and promoting public officers could be compromised politically, having regard to how ministries are structured and how permanent secretaries behave, as we recently saw in a hearing at AJSC recently, where a permanent secretary whimsically, capriciously, without any accountability, expended $92,000. Madam President. No, Madam President, I am saying this to let you know that in this particular matter before us, we have some reservations. And this is why I asked the Senate today, through the Minister of Public Administration, through you, Madam President, to come and give an account of when did they get the approval, could the minister provide us with a legal notice? Madam President, may I draw to your attention a legal notice which was issued in 2006 by the Public Service Commission with the approval of the Prime Minister pursuant to Section 127 of the Constitution, where they gave certain powers to the fire service and the chief fire officer in this instance. And Madam President, it is detailed. There are some 10 to 15 pages of detailed information in this public notice. I have searched, I have asked the librarian in this parliament to provide me with a legal notice, giving the permanent secretaries in these so-called, these 6 ministries, the power to recruit, Madam President, and the power to discipline. And up to this time, as I speak, Madam President, I am yet to receive any legal notice. There is no legal notice that has been brought to my attention, and from what I have learned, what we have is a public relation gimmick on the part of the Ministry of Public Administration and Communications, because no public service commission can delegate onto any permanent secretary in any ministry any power to employ public servants, to recruit public servants, Madam President, or to discipline public servants unless it is gazetted and there's a legal notice to that effect. So I have called on the Honorable Minister through you today to explain to this Parliament and Senate and to the public where is the approval given to these 6 ministries to recruit personnel to fill positions within those respective ministries, Madam President. So this, as I said, is a very unusual development, because I myself, in another incarnation, recall trying to get this same power, and it was not granted. And the reason why it was not granted is because the Public Service Commission guarded very jealously that function and responsibility under Section 120 and 21 of our Constitution to be allowed that power, that independence rather, to recruit, to promote, to discipline, and to transfer. And it was very difficult to delegate that to permanent secretaries. So that is why I found it very interesting. And I await the response of the Honorable Minister of Public Administration to explain to us how this regime or this government was so lucky to get the Public Service Commission to grant it this power. And yet still, Madam President, there is no legal notice, there is no legal order, nothing has been gazetted. So are these ministries, Madam President, could we be advised, I know I have 1 minute now, Madam President, could we be advised by the Honorable Minister of Public Administration and Communications how many workers have been recruited thus far in these 6 ministries? When were they recruited? How were they recruited? Was the Public Service Commission involved? These are some of the areas that we would like to have clarified so that we will know what is taking place. Thank you very much, Madam President.
Minister of Public Administration and Communications.
Madam President, thank you for the opportunity to address this Honorable House on the motion brought by my friend, Senator Mark, on an important issue, and I thank him for giving me yet another opportunity to address the matter. It is important that I recite the precise wording of the motion. Open quotes, the need for the government to provide the public with good reasons for requesting the Public Service Commission to delegate its recruiting and disciplining authority to permanent secretaries in 5 ministries. I must admit that I am disappointed in Senator Mark, who is not only one of our longest serving parliamentarians, but also a Minister of Public Administration, for the wording of this motion. In fact, Madam President, he is the first person to serve as a Minister of Public Administration with full cabinet authority. Madam President, the Public Service Commission is an autonomous constitutional body established under sections 120 and 121 of the Constitution, with the power to appoint persons to hold or act in offices in the public service, including the power to make appointments on promotion and transfer and to confirm appointments, to remove and exercise disciplinary control over such persons or acting in such offices, and to enforce standards of conduct on such officers. Further, under sections 127 and 129 of the Constitution, the Commissioner is granted additional powers with the consent of the Prime Minister to delegate any of its functions, impose duties on public officers, and regulate its procedures. I say this to point out that the Public Service Commission does not pander to the whims of any politician, and I have certainly not made any requests to the Public Service Commission to delegate any functions on any 5 ministries. Monumental changes are taking place in the public service, but it is clear that Senator Mark is overwhelmed by the changes and does not understand them. I will attempt to enlighten my good friend. Since I appreciate that this motion is born out of ignorance, not malice, although as a Minister of Public Administration, I think the goodly Senator should have known better. Delegation of authority in the public service is done pursuant to Section 127(1) of the Constitution by way of a delegation order. In 2006, the Commission amended its delegation of powers to permanent secretaries, heads of department, the Chief Administrator, Deputy Permanent Secretaries, and Directors of Human Resources by order of legal notice number 105, dated the 24th of May 2006. These delegated functions include acting appointment up to reign 68, except in offices requiring consultation with the Prime Minister for a period of 6 months. Appointments on a temporary basis for periods of 6 months after first appointment by the Commission. Confirmation of appointments, transfers within ministries, departments, and the Tobago House of Assembly, exercise of disciplinary control in respect of minor infractions in the Code of Conduct. So, Madam President, the delegation which Senator Marks thinks is referring to actually took place in 2006, 11 years ago, on May the 21st, 2006, with the publication of Legal Notice 105. Now, I understand what he was really attempting to refer to was my recent announcement in the news release that permanent secretaries have been given the authority to recruit persons for peculiar positions in 6, not 5, 6 ministries. But that authority, and the reason why you would not have been able to find it, Senator Mark, has been in existence since 2007. When the Public Service Commission regulations were amended to include Regulation 13, Clauses 5, 6, and 7, to provide ministries and departments with the power to issue notices of vacancies and set up selection boards to interview candidates. This was done by way of amendment of the Public Service Regulations with the consent of the Honorable Prime Minister and not by way of delegation. So there was no delegation order. So on that score, Senator Mark is 10 years late. On the issue of delegation, he is 11 years late. So on the issue of recruitment, he's 10 years behind. Now I know, Madam President, that the PNM is generally 10 years ahead of the UNC. But on the issue of public administration, it could be longer. So try as they might, and Senator Mark has been trying for 26 years, they just can't keep up. We are at least 10 years ahead of them. Now, the amazing thing is that during the time when the delegation orders were issued and published by legal notice, and when the amendment to the public service regulations were done, Senator Mark was a member of this House and was party spokesman for public administration. So he was clearly sleeping on the job. But, Madam President, the situation gets even worse. Under the previous People's Partnership Administration, consultants Deloitte and Touche, in collaboration with the Institute of Public Administration, were engaged in a project for the institutional strengthening of the Service Commission's department. They approved a report on the future state for the public service. It was suggested in the summary of phase 1 of their recommendation, 4 things: that the Commission's role be one of policy directing, monitoring, and reporting. The Service Commission Department's role under the leadership of the Director of Personnel Administration include provision of support to client, ministries, departments, and agencies, including complex and difficult files, serving the commissions in fulfilling their policy monitoring and reporting roles, all recruitment, except for recruitment of last cross-government categories, staffing and discipline, be delegated to ministries, departments, and agencies. The permanent secretaries and heads of department assume responsibility and accountability for these functions consistent with the policies and procedures set out in the public service regulations by the Commission. The committee which made that recommendation, Madam President, was chaired by the then Minister of Public Administration, Caroline Sipasad-Bechan, in August 2015. It was a recommendation that has been approved since 2007. It is to be noted that information regarding how the ministries were selected is within the Service Commission Department and the Public Service Commission. But if Senator Mark really wanted to know why the Commission gave the power to recruit persons for the 6 ministries, all he needed to do was to ask Senator Amin, who sits to his left. She was a member of the Joint Select Committee, which summoned the Public Service Commission, and they were told that there were 9,000 vacancies in the public service. So there are approximately 20. Thank you, Madam President. I just want to say that the authority is given under the amended regulation, and to respond to Senator Mark, last Sunday, page 21 of the Sunday Express, the first advertisement announcing the recruitment of public servants by the Ministry of Energy and Energy Industry started the ball rolling. So you will expect to see more ministries applying directly for staff and filling the 9,000 vacancies which Senator Mead will know about. Thank you.
Senator Mark.
Yes, thank you very much, Madam President. Madam President, I deal with the Sea Bridge at this time. Before the collapse of the Sea Bridge, we had a situation, Madam President, where the Superfast Galicia operated, and everyone could have testified that the Superfast Galicia did an excellent job. Even the government recognizes that. But because of internal shenanigans by the PNM, and the ringleader being the former chairman of the Port Authority, Christine Sahadio, misled the country completely, because it appeared, Madam President, that that particular chairman, along with other elements, had their own agenda. They wanted their own barge, they wanted their own boat, and therefore they came up with a word called corruption, which they are very familiar with. And Madam President, what they did, they sought all kinds of reasons to justify why they would not renew the Galicia. It was because of the government's refusal to renew and to give a contract to the Superfast Galicia that the people of Tobago and the trade that goes on between Trinidad and Tobago has been just suffering and suffering because of other persons' self-interests and machinations. That is what is happening. So, Madam President, what has happened in the Sea Bridge requires a criminal investigation. We need to really get to the bottom of this. Maybe we need a forensic investigation to determine, for instance, who are the real owners of the two boats that have been hired by this government. We know for a fact that one David Brash who is the gentleman who has the MV Transporter, is a well-known financier of the PNM. And what is even more alarming, Madam President, is that we have learned, Madam President, that this barge gets $10,000 a month, a day. A day, Madam President. $10,000 a day. And Madam President, we were told that that barge was going to be there for only 1 month. We are now going into 2 months, and the barge is still operating. I want the Minister of Transport, who is going to be answering me this evening, to tell us whether this owner of the MV Transporter is receiving $10,000 in 10,000 US, or whether they are paying him in TNT dollars. We need to know this because, Madam President, we now have a shortage of foreign exchange. Chicken prices going up because of a shortage of foreign exchange, US dollars. And, Madam President, in addition to this company, right, the MV Transporter, lucky to get this particular contract, we have the MV Provider. And that boat is being provided for very nicely. And Madam President, it gets curiouser and curiouser like Alice in Wonderland. This boat, MV Transporter, we understand, is getting US $14,000 a day. Madam President, $14,000 a day, or close to $100,000 a day. And Madam President, this boat, we understand the owners are from somewhere South Trinidad. We are doing our investigations to connect the dots. And once we connect the dots, we'll be able to expose this whole corrupt ring that has been established, Madam President. So they give the impression to the country, Madam President, that they had to get rid of this thing. The Minister of Works and Transport, who is not here today, he said that they were being held to ransom. All kinds of excuses, Madam President, as to why they would not renew this particular contract. Madam President, the people of Trinidad and Tobago, and particularly the people of Tobago, are suffering as a result of this crisis, Madam President, as a result of the collapse of the Sea Bridge. Every day, Madam President, there is some crisis on that port. Madam President, the government got rid of Bay Ferries, right? And they bring some fella called Magellan or Magellan. He take over. And as soon as they take over that maintenance part, the boat gone, break down. Every day is break down. To the point that the Prime Minister of our country said there was human interference, meaning there was sabotage. Luckily, the Honorable Minister of Transport came later on and said there was no sabotage. So the Prime Minister is being told one thing, Madam President, and the Minister of Works and Transport is being told another thing. So what you have actually happening on the Sea Bridge, Madam President, is a whole conspiracy hatched by the PNM in an effort, Madam President. Yes, ma'am. Yeah, well, I'm saying, well, I don't know. Well, it was given birth, Madam President. If it wasn't hatch, I take back hatch. But they birthed it. That's this particular, yeah, and they conceived.
Word conspiracy.
Conspiracy.
Yeah.
Okay, sorry. All right. So, Madam President, we want to get answers. And I think that the time has come, as I said, that we should have a forensic inquiry into this whole transaction. How come, Madam President, this particular owner of this barge from South Trinidad, called David Brash, was so lucky to be selected? And he so happened to be a financier of the PNM. How come, Madam President? You find that strange, Madam President? So that has happened. So whilst, and Madam President, what is even more alarming, Madam President, what is even more alarming is that this government is paying more money today for these two vessels than they paid for the Galicia. They are paying more money, Madam President, for those two vessels today. I think it is almost $150,000 a day. And whereas the Galicia was costing us just close to 100,000. And so, Madam President, I think that the government owes this country an explanation. They need to answer and stop hiding behind distractions. So the distraction was Nairi Alfonso was part of, and they were going to have a criminal investigation. And whatever happened to that, Madam President, the Minister of Works and Transport threatened to sue the super fast Galicia owners because he said they breached contract. Madam President, up to now, no legal action has been taken against, not even a letter has been written. I know why, Madam President. They have no basis they cannot sue. They cannot sue that particular company because the company did not breach any particular arrangement. And therefore, Madam President, the government needs to come clean with the people of Trinidad and Tobago on the real reason for that particular sea bridge disaster. Don't come with cover-up stories, Madam President, to give us the impression that it had to do something with somebody blackmailing you. It was no blackmail. It was the government of Trinidad and Tobago trying to get its hands, Madam President, on the cookie jar in order so that they could feed at the trough, Madam President. And that is what is taking place in Trinidad and Tobago. And that is why I'm calling for a forensic inquiry into this whole matter and a criminal investigation into this whole matter, Madam President. This is what is called Ferrygate. It is a Ferrygate that has taken place, Madam President, and we need answers to this matter.
Before I call on the Minister to respond, I just need to urge members, when making reference to parties who are not members of this House, to be, freedom of speech is sacred, yes, but, be careful when you're making reference to persons outside the House, because they don't have an opportunity to defend themselves. Leader of Government Business, you have 10 minutes.
Thank you very much, Madam President. Before I begin my contribution in response to the motion of Senator Mark, on a point of clarification, Madam President, during my intervention at the end of urgent questions, it was never my intention to question the authority of the chair to approve urgent questions. I want to make that abundantly clear. I was making the point in the context of time management if I was ambiguous or if I came across as if I was challenging you, Madam President, I humbly apologize. I humbly apologize. I humbly apologize. But Madam President, let me get to the point. The motion before us today, which states that there is a failure of the government to appropriately address the issue of the sea bridge between Trinidad and Tobago, this is farthest from the truth, Madam President. Permit me to say, Madam President, that since this serious matter arose, this government has tirelessly explored solutions to alleviate the distress levied on the citizens who are dependent on the operation of the sea bridge. Madam President, there are three key areas that I need to address. First is the roll-on, roll-off cargo vessel. The charter hire of the MV Superfast Galicia by a previous administration was subject to much contention. Firstly, because of the size of the boat and the docking facilities next to the hire causing major damage, an associated problem, particularly with the procurement process. If we consider the trail of events with the understanding that the Intercontinental Shipping had held an 18-month contract with the Port Authority, which was due to expire on October 31st, 2017. We will see that it was always this government's intention that during that period until October 31st, 2017, that during that period a replacement vessel would have been sourced. Madam President, because of that, the Cabinet got involved. In that context, the Cabinet agreed to take the following measures. One, to secure a suitable vessel on a 3-year time charter to provide coverage for the service in the medium term. And two, to implement a public procurement process for the design, build, and finance of a suitable roll-on, roll-off cargo vessel as a long-term solution once and for all. In facilitating these workable solutions and the immediate needs, the way forward, we approach it at three stages. One, an interim solution. Madam President, in response to Senator Mark, on the 31st of March 2017, Intercontinental Shipping, agents for the MV Superfast Galicia, served 14 days short notice to the Port Authority of the termination of the roll-on, roll-on contract, which was due to expire, as I said, on October 31st, because they wanted a 5-year extension without any public procurement. There has been a rant and rave in this country for public procurement, and they wanted you to roll over that contract for 5 additional years. Obviously, whether you want to use the word blackmail or coerce or what, that was unacceptable to this government. Their service ended on April 21st, 2017. Obviously, we were caught in a bind. The Port Authority then invited proposals from interested parties and also received unsolicited proposals from interested parties, firms, for the provision of short-term...
4211, the member is reading.
Yes, but I have to read. Yeah. I'm not normally a reader. They've received unsolicited proposals from interested firms for the provision of short-term vessels. Madam President, you do not just take a saucer boat like a maxi taxi.
Not on a shelf.
You have to go through a procurement process. 2 vessels were made available after a long search. It was the MV Atlantic Provider, a roll-on, roll-off cargo vessel, chartered at a daily rate of $14,000 US. Senator Mark is right. And the MV Trinity Transporter, a tug and a roll-on, roll-off barge, chartered at a daily rate of $8,000 US. Madam President, we would be the first on this side of the House to admit that these vessels are not the ideal solution, but they are the only an interim solution given the immediate circumstances that was facing the government. And Madam President, you made the point on the brushes. Let me just say, for the purposes of this country, that the Brush family, who is the owners of Well Services Petroleum Company and Lease Operators Limited, is one of the most prominent businesses in Trinidad and Tobago. They produce 5,000 barrels of crude oil for this country. They own foreign exchange for this country. I have no beef for the Bash family. But what I'm saying is that they have a businessman and a business family of long standing. And I think it is unfair, and I consider it unfair for the statement that was uttered by the Senator Mark. Madam President, on the medium-term side, in addressing the medium-term solution on April 1st, 2017, the Port Authority invited duly qualified brokers to tender for a vessel on a 3-year time charter. These tenders were closed on April 24, 2017. Unfortunately, only one proposal was received, which was unsuitable, and the tender process was deemed unresponsive and was aborted. Luckily for us at this point in time, Madam President, in this respect, the Board of the Port Authority has been fortunate to secure the technical advice and services of the World Bank, which has agreed to review the model of ownership and operations in the inter-island ferry and the financing and design of vessels, which are suitable to meet the long-term operational requirement. Let me move on to the fast ferries. Frequency of the breakdown and the consequent unreliability of the fast ferry service, the government intends to take immediate steps to thoroughly overhaul and rehabilitate the 2 in-card fast ferries, the TT Express and the TT Spirit, that it currently owns. This is to ensure that they are restored to full functionality in order that they can provide the same level of quality service on the route as they did prior to 2010. Madam President, in that regard, arrangements are currently being made to immediately source an additional catamaran passenger vehicle fast ferry, vessel fast ferry, similar in design, feature, and capacity to the current in-card vessels, such as the in-card 046 or any other suitable fast ferry. And with regards to technical management services, it is well known that Bay Ferry's contract was terminated. They were in this country for almost 12 years as a foreign Canadian company. There was no mentorship, there was no training of locals and what have you, so we had to buy the bullet and try to see if we could have gotten a local entity to provide such services. It obviously didn't work out the way we hoped it would have worked out, and we are going back out to the market now to source a maintenance contract for boats. But Madam President, before I close, I want to emphasize that this government continues to take all possible steps to resolve the many issues that face the sea bridge service in the shortest possible time. And let me close by quoting Columbus. You know, before Columbus discovered, well, I want to be corrected by Senator Baptiste Primus. Before he visited Trinidad, he was stuck in the doldrums, and there was going to be a mutiny. And he said, "Give me my men but 3 days." And then the wind rose, and he found Trinidad, and he called it La Trinity in honor of the Trinity. I ask this country, through you, Madam President, to give us a little more time. And I want to guarantee this nation that that issue of the sea bridge and the service that the sea bridge provides, both for cargo and passengers, will be solved once and for all. I thank you.
Honorable Senators, the question is that this Senate do now adjourn to Tuesday, the 13th of June, 2017 at 10:30 a.m. All in favor say aye. Aye. Any against? The ayes have it. This Senate now stands adjourned to Tuesday, the 13th of June, 2017 at 10:30 a.m.